I hit the broadcast. Good afternoon, ladies and gentlemen. My name is David Donovan, and I'm president of the New York State Broadcasters Association, and I would like to welcome you to the NASBA Political File webinar. All stations that accept candidate and issue ads must have an online political file, and this is part of your overall public file. Recently, the FCC has shown a heightened interest in the broadcaster's online political file. Unfortunately, a number of stations may not understand these obligations. This webinar will focus specifically on the Commission's political file requirements and recent FCC actions to ensure compliance. But right at the front, we will do some formal introductions a bit later, but I want to thank the FCC's political team. These are the folks who make the decisions. I also want to thank the NASBA Executive Committee, Mark Gordon, President, Dave Arlen, Bob Houghton, Dewey Bruce, and Polly Prince Johnson, past president, for their support in getting this webinar together. A few housekeeping items. First, this webinar will be archived, assuming I hit the right buttons. The link and the slide deck will be sent out to the state broadcaster associations, and you will be able to obtain the link and the slides through them. We will be answering questions after the presentation. You may submit a question during the presentation using the Q&A or the chat button at the bottom of your webinar on your screen. Given the large number, there will be no verbal questions. If you are watching on a computer, you should be muted. If you're calling by phone, please mute as well. So let's get started. I'd now like to introduce Jack Goodman, longtime communications counsel in Washington, D.C. and political broadcast expert, and the former general counsel of the National Association of Broadcasters. Take it away, Jack.
Thank you, David. And let me start our slide presentation, which I'm going to go here. So I want to thank everybody for participating, and particularly the FCC staff. And let me introduce them to you. We have the entire FCC political programming branch. This is the brain trust of the FCC on political programming, and its chief, and the person who has been doing this for a very long time, is Bobby Baker, who may be familiar to most of the people on this call, and the people he works with, Gary Schonman and Sima Nilsson. And they are going to be the primary presenters here. So I am going to turn it over to Bobby to start. Bobby?
Okay, thanks, Jack. This is kind of an unprecedented situation, as David alluded to. This is the only webinar, and I've done hundreds of them, that's ever been a single issue webinar focused on the investigations that have led to this moment in time. Our initial investigation began over 1.5 years ago. We were investigating one of the big radio groups, and what we found in that investigation, going through each and every one of their stations and throughout the United States, the amount of non-compliance was stunning. And ultimately, we were in negotiations with that particular broadcaster, or the broadcaster group, and then because the other large radio groups apparently were having comparable problems to the ones that we were investigating, they came en masse under the auspices of the National Association of Broadcasters. They came to the FCC with CEOs and presented their case, which was not to make excuses about their lack of compliance in the political file realm. And so we inaugurated a process of compliance plan. An initial plan with them lasting 5 weeks allowed them to use this spreadsheet, which some of you have become familiar with. And so ultimately, we resolved our investigation with those licensees. through these consent decrees, which will require compliance plans from them for the remainder of this year and through the end of 2021. Once we were done with the investigation of the big groups, it came to our attention through our audio division that smaller broadcast radio groups and radio individual licensees were having problems that were very similar to the ones that we were seeing with the large groups. And so we then exercised our discretion to inaugurate consent decrees with what at this moment in time has been 107 different licensees representing approximately 190 stations in the United States. These consent decrees will continue to roll through the entire renewal process, which every 2 months there's a new step in that. And so there are licensees that have not received consent decrees who may very well receive them if they have been unable to certify in their renewal applications that their political file had files that were not timely file, I guess is another way to put it. In any event, that's where we are today. We recognize, Gary, Sima, and I recognize full well that for a lot of the smaller licensees who don't have law firms on retainer or don't have regular legal advice, the receipt of these consent decrees is probably a pretty dramatic event in their lives. And so what I am pledging to you, and I have the full support of my staff, Gary, Sima, and I will make ourselves available to anybody that chooses to contact us through the contact information you're going to get at the end, which includes direct email addresses for the three of us, telephone numbers for the three of us, our cell phones at home, which we are now using exclusively since we're all working remotely. And I pledge to you that to whatever extent possible, we will help you and assist you in any of the mysteries of the consent decrees or any other aspect of this. So feel free to email us, tell us that you'd like to talk with us, send us your own telephone numbers if you choose, we'll call you, and we will try to help you as much as humanly possible with that part of the process. So you can move on now. Okay, so what you hopefully will learn, at least you'll get a, not a full nuts and bolts, but you'll have a better comprehension probably than you did when this began. We're going to explain to you the events that trigger for you to upload disclosures into your file. We're going to provide you with the information that needs to be uploaded. We're going to tell you about the timing, which is the crux of the issue that we've been dealing with in these investigations. This has all been about the timing of the placement of this material in the files and the mechanics of uploading records to political files. And ultimately, we will give you at least as much information as we can about the consent decrees themselves for those of you that haven't received them. And for those of you who have received them, who find them to be somewhat mysterious, we can hopefully shed some light on that.
Thank you, Bobby. Now, Sima, would you talk to us about what the Commission's view is, why the political files are important?
Sure. Well, I would think that most folks watching this are, have some experience dealing with the political files back from their paper form days when you maintained everything in the station. And those reasons haven't changed, even though we're in an online world now. The contents of the files help candidates devise their strategies for placing and buying ad time. And they keep the public informed about the races, the candidates, who's spending what money and where they're doing that. And the online system now, this centralized database makes it easier for members of the public to access all of this information in one centralized location rather than having to visit various stations in their community. So those are the main reasons as are laid out in the slide here.
Thanks. So Gary, let's start turning to the rules. And the first question is, what triggers an obligation to put something in your station's online files. Gary, you're muted.
Sorry about that. This is the meat and potatoes of what starts the process going. Let me start out by saying that the FCC looks at political ads, divides the political ad universe into two types of ads. There are ads that are by or on behalf of candidates or their authorized committees. And when I say candidates, I mean legally qualified candidates for federal office, state office, or local office. So from the president down to the proverbial dog catcher. If you receive a request for the purchase of airtime by or on behalf of a legally qualified candidate, that will trigger obligations to put information in your online political file. The other type of ads that we're concerned about are issue ads, but only certain types of issue ads. If you receive a request from an organization that's not associated with the candidate, it could be a public interest group, it could be a political action committee, it could be an individual for that matter who just wants to make a statement. If you receive a request to buy time on the station by a non-candidate organization or entity, and they are proposing to have an ad on your station that communicates a message relating to, and here's the key term, that relates to any political matter of national importance, that will trigger uploading requirements for you. It is not always easy to determine whether an organization is proposing to run an ad that communicates a political matter of national importance. For example, if you have, if an organization wants to approach you about running an ad that is proposing to support a move on the ballot to build a gymnasium on a local high school, might be a political matter, but it's not of national importance. That would not trigger uploading requirements for you. But if it's a national matter, a political matter of national importance, then it would. And sometimes it's difficult to tell. If it's really difficult to tell, give us a call or give your lawyer a call. But what we have decided is that we will defer to your good faith judgment about whether a borderline case is a political matter of national importance or a political matter of local importance. And again, if it's of national, it does trigger uploading requirements. And if it's strictly local, state or local, then it does not trigger uploading requirements. So just to summarize, the triggering mechanisms. If you receive a request for the purchase of time by a legally qualified candidate for federal, state, or local office, that will trigger uploading requirements. And if you receive a request for the purchase of time by an organization that wants to run an issue ad that communicates a political matter of national importance, that will also trigger uploading requirements. And keep in mind, when we talk about issue ads, an issue advertiser can advocate for or against an issue. An issue advertiser can advocate for or against a candidate. So we might be speaking about a candidate when it comes to an issue advertiser. So just keep that in mind. And again, the triggering mechanism occurs when you receive a request for the purchase of airtime. And not all requests, for example. If you receive a request and they're just, well, if you're approached by an advertiser, whether it's a candidate or an issue advertiser, and they're just kind of fishing around, they want to get a lay of the land, they want to know what avails you have, what the rates are, that's not a firm request. They're just trying to get the lay of the land and trying to determine what's out there. But if you receive a firm order from an advertiser for a specific schedule, that will trigger reporting obligations. Okay, so once you know that you have to upload because of the type of request that you've received, then the question becomes, well, what do you have to put in the political file? What's necessary to upload? And we sort of look at this from different perspectives. We certainly want to know about the request and about the time that's being aired. So for candidate ads and issue ads that involve a political matter of national importance, the things that we want to know about the request and the time sold are whether you've accepted the request or rejected the request by the advertiser. And of course, if you accept it, we want to know the rates charged. We want to know when the advertisement was or will be aired, the date and the time. The statute asks for the class of time that was purchased or proposed to be purchased, and also the final disposition of the purchase. Now we understand that a lot of stations will stream their programming over the internet, and the FCC is only concerned about ads that are broadcast. So if you're doing both broadcast and streaming, simultaneously, well, then it's being broadcast. So the FCC is interested in having information about those ads uploaded. If the programming is purely being streamed, then any ads that run on your streaming platform are not ads that information about you would have to put in your political file.
And Gary, the same is true for websites that a station has, even if it doesn't involve streaming. In other words, an ad sale only on your website would not have to be put in the public file. But if it's a combined purchase of both internet and broadcast, then that would trigger an upload obligation. Isn't that right?
Yes, that is correct. The key thought here is that if it is broadcast, information about that ad has to be uploaded to your political file.
Thanks. And now let's drill down a little more into the specific things that have to be uploaded for the different types of ads. So Sima, let's talk about candidate ads, please.
So in addition to that information that's common to both types of ads, for for candidate ads, in particular, you need to include information that provides the name of the candidate, the committee, the candidate committee, and the treasurer of such committee. And I'm just noting this because we had some discussion on this. The treasurer requirement is set forth in the Communications Act. I'm not sure that it's in our rules, but it's in the act, so you have to put it in there. And then the note down there is actually it's an important piece of information that in the case of free time that's provided to a candidate, you still need to make sure that, even if it's not an ad, but it constitutes a use, for example, and remember that a use is a positive identifiable appearance of that candidate. So if they get free time because they're on-air talent, or if they happen to be somebody who is an actor or actress and has appeared in programming that the station decided to run, you still need to make sure that you record that time in your political file.
But Sima, just to make clear, that doesn't apply for things that are exempt from bona fide exemptions from equal opportunities, such as appearances on your news or on bona fide news interview programs, things like that.
That's right. Yes, there are some exceptions to this, which I don't think that we're covering in this particular.
No, but I want to make just clear that not every use free time would have to be uploaded. It's only the ones that would trigger are not exempt from equal opportunities. And this is an area, if you're concerned, you should call the commission, call your council, do something if you have doubts about it. All right, sorry.
No, I was just going to say, we do get a lot of questions on, determining whether or not something is an exemption. So
Exactly. Gary, how about the same question for issue ads? What has to actually be specifically uploaded?
Well, for issue ads, and again, we're talking about issue ads that involve a political matter of national importance. We want to know information about the contents of the ad and about the entity that's paying for the ad. So we want a list of all political matters of national importance that are referenced in the ad. So that requires you to, if you're a TV station, to look at the ad. If you're a radio station, certainly to listen to the ad, and to make a list and upload that list to the political file about all the political matters of national importance that are referenced in that ad. And again, because an issue ad can concern issues of national importance, as well as advocating for or against candidates and elections. I mean, an issue advertiser can advocate for or against lots of different things. For example, if an issue advertiser is advocating for or against a particular federal candidate, then that is information that would have to be uploaded. If the issue ad talks about an election, a federal election, then information about that has to be uploaded. And again, if the issue advertiser is advocating for or against legislative issue of public importance that's pending in Congress, that also, information about that has to be uploaded to your political file. So again, a list of all political matters of national importance that are referenced in the ad. And then we want to know who's buying the ad, who's buying the time on the station. So we want to know the name of the person or entity that purchased the time. We want to know the name and address and phone number of a contact person for the organization. And we also need a list of the chief executive officers, apparently, essentially the people who head up the organization that purchased the ad.
Yeah. One thing people may want to remember is that if you are getting, say, a PAC ad that is running a flight of spots advocating or opposing the election to a federal office, they may have different issues in each one. And under the commission's current interpretation, you may have to say the ads that ran on this day involve Social Security, the ads on this day involve COVID, et cetera, et cetera. So you may have to actually drill down a little further, ad by ad, where you have third-party ads dealing with elections. So turning to the issue that has created the most, created all this inquiry by the commission, is when things have to be uploaded. Bobby, can you talk about that? And you're muted.
Unmuted. Am I back?
Yeah, you're back. Yeah, thank you.
All right. I think I mentioned this earlier on. This timing issue is really the crux of the issue that we've been dealing with in these investigations. It's not the content of the ads, some of which Gary has referred to, but basically, and this is pretty simple, in the scheme of political programming regulations, not all things are simple, but this one is pretty straightforward. And the rules require, and the Act has codified the same requirement, that the material needs to go into the file as soon as possible, which is immediately, absent unusual circumstances. And what we've allowed for in our sort of informal review standard, we allow for at least a day, 24-hour period to be the template for anything outside of 1 day late. We would consider to be untimely. Now, when ads are bought on a Friday and the ad doesn't get uploaded and the material is not uploaded until Monday, we would forgive the weekend because those are not business days. And we often have situations where it looks like the upload may have been 3 days late, but because of the weekend, the interceding weekend, it really is still only 1 day late. It is incredibly important for people to understand that unlike the paper files, for which we had no certain way of knowing how late and timely or untimely these ads were, in the digital file, the online file that you're now required to upload your materials into, we see they are date stamped. automatically. It's a digital date stamp. It tells us literally the day that this material was uploaded. And I think it's in part because of that, and maybe the lack of knowledge of that, that some of the stations were kind of overwhelmed by the fact that we could identify, you know, these ads were 50 days late, these were 20 days late, these were, you know, all the different ways that we could actually see in real time exactly how late these things were. So it's a far different cry from what it used to be with the paper files, because even when investigators would go into stations and ask for a paper file, people could scramble around and start throwing pieces of paper in a folder before they brought it out. So there were all kinds of ways, I guess, to use, it's not a legal term, but where stations could fudge or place things if they got a letter of inquiry from the commission, they could create things that they should have done 2 weeks before and just put it in the file and no one would know the difference. And it's no longer possible to do that. And I think this exercise, this investigation has really revealed our ability to be very accurate about just how untimely a lot of the files are. So that's an important thing to remember.
And the other thing is, if you have to change, if you have mistakenly upload something, for example, you've uploaded it to the wrong folder and you replace it, it's best to actually put on the material you upload that this is a replacement for something that was uploaded on a previous date. So it's already in the file explaining what otherwise would appear to be a delay.
You know, Jack, if I could jump in on that and add something to that, is that if a station has to supplement something that it has already uploaded, they should add it to an existing file, because if you upload anew to a new file, then that gets itself a new date stamp. If you want to associate it with an existing file, just place it in that existing file so that original upload date is controls.
Actually, Gary, I think it's the folder. They place it in the existing folder. If they replace the actual file document, that triggers a new date, but they can add another file to the folder. It's how
Yes.
I think that's what, okay. So Bobby, next question, how long do people have to keep these file records?
They're required to retain the information for 2 years. We've never specified whether that's 2 years from the actual date that it was uploaded. I guess, I mean, that would be a legitimate way to look at things, except that then stations would be purging the documents after 2 years in a rolling capacity. I think most broadcasters have determined that the most appropriate way to deal with these situations is certainly to retain the information for 2 years beyond an election day. That way they have a date certain, and then they can literally purge their files all at the same time when they know that they're at least 2 years out.
Thank you. Now, one of the questions I think a lot of people have is forms, and should you or must you use a form to capture this information? David, what's the situation on forms?
Yes, and we've received a lot of questions about forms. You are not required to have a specific form under FCC regulations. However, a lot of state broadcasters have their own forms, but the NAB's PB19 form will include all the necessary elements that one would need to file to comply with these rules and regulations. And so those forms from the NAB are available. If you're an NAB member, they're available for free. If you're not an NAB member, you may purchase them. And on this slide, what we do is we have a link to the NAB forms. It contains separate forms that are both for candidate and for issue ads. And if you fill this out, you will in fact meet and comply with all the requirements that we've talked about above. If you're trying to fill out your own form, you just have to be very careful if you're trying to make one up to make sure that you cover all the issues. So we suggest if your communications lawyer has forms or your state broadcasters have forms, or frankly, we highly recommend the NAB PB19 form. We believe that will resolve most of the issues. Stations are responsible for uploading that accurate information. And so the FCC has its authority over the station, not the agencies or your advertisers. So you need to make sure and use the forms and use your best efforts to obtain information, both from the candidate committees, or if there are issue ads involving PACs or other groups, that you get that information to fill out the NAB form.
And that may require you to look at the ad, particularly, for example, on issue ads, determining what issues are addressed. You may have to look at the ad yourself and make a judgment and put it in if the advertising agency doesn't supply it adequately.
Yes, and Jack, just to add, for the PB19 form, for issues, you have to list who the executive officers are and things of that nature. And I believe the NAB form will cover all those issues.
Yes. Okay, so those are forms. So Sima, help us, people who are not as familiar, how this process actually works to upload documents onto the FCC's online public file.
This is the exciting stuff. Okay, so hopefully everybody is familiar, at least, with where all of this information resides. But for those who aren't, the Commission hosts the database, the online public inspection file database, for, at this point, all licensees that are required to maintain their files online. And that is the world of our licensees. So for first-time users, you are, well, let's start with the information on the slide here. So make use of the folders and the subfolders that are already created in here for you. They are there because you need to actually categorize the information appropriately under our rules. And also, it's not a very useful file if you don't, appropriately place information into the right space. If you with political files, and particularly if you're just throwing them into an applications folder, we're not going to know that they're there. The public looking for your files isn't going to know to look there, and that could lead to problems with compliance down the road. Okay, so for the actual mechanics, if you are a first-time user, what you'll need to do is go on to the public files page, which the URL is indicated there. Make a note of that. And then you'll want to go to the For Filers tab, which will be at the top. There's a banner with various tabs. So there's a public-facing side, for anybody who's looking to see where the information is housed, and then a For Filers tab, which you will click on, and then go to your owner dashboard. And the piece of information that you need to have when you're starting this process is your FRN and its associated password, because the system itself will generate your passcodes, which are permanent. You'll want to keep those handy based on all of the entities associated with that FRN. So make sure you have that information. If you don't have that, I believe there's a CORS help desk that can provide that for you and help you set up your password. But hopefully everybody has that, because for all licensing purposes, you need that. So once you locate your public file passcode, you'll go back to your screen for filers, and you will enter the passcode associated with your particular facility and log in. Once you're logged in, you want to select Manage Public Inspection Files in order to start uploading information. So there are various folders that have already been created. A lot of these are system folders. So for the system folders, you're not actually uploading information. You won't even have the option to upload information, you'll see. It's when you get down into the subfolders where you'll see a tab to actually upload information. So the creators of this database have made it easy for users to make use of these subfolders in that way. So once you've selected political files, you want to find the appropriate category of political files. So that's federal, state, and local, or issue. There are some subfolders that have not been pre-created because, the commission and the contractors who set this up for us didn't have access to the whole world of political races out there. So for the local ones, you can create a new folder and upload your information into that folder once you start this process. Okay, so when you've clicked on the folder for the correct race, you open it up, and there will be an upload documents option. And the database accepts PDF, Word, text files, and Excel. And then the process is simply dragging and dropping. So anything that's on your computer in one of the appropriate file formats, once you select upload files, you just literally take your cursor, click on the document you want to add, and drag it into the folder. And everything will be converted to PDF once you've uploaded the files. A couple of notes. If you haven't looked at the user side, only the public side, there are a lot of icons and other formatting things that you won't see on the user side. It's much more straightforward. So don't worry if it doesn't look familiar to you as a user for the first time. There is a demo, which is about an hour long, but it's very thorough, and it's actually what all of us have used internally to get familiar with the process of adding documents to your folder. So I recommend that everyone take the time, when you have an hour free, to watch the demo. We have the link right there. And there is an actual database manager who takes you through a dummy file scenario, so you can see exactly how you drag and drop, where everything is housed, what all the tabs are used for. And obviously, this is not just for political file use, but for all your other public file requirements.
Sima, if I can jump in, I think this sounds, particularly where you go through click, 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 it sounds more complicated. Once you're into it, it's actually pretty self-explanatory and user-friendly. It is not that hard to do this. And if you go in and play with it, it's pretty easy.
One thing that I meant to note, in addition to system folders that are separated by type of race, there's also, it's all initially separated by year. So you'll want, obviously you'll want to find the year of that particular ad. Once you open up the year, then you see the categories, and that's true for every year folder.
Thanks very much. That was great. Gary, talk to us a little about the consent decrees, how they came about, what they have provided, and what obligations they impose on people who end up with a consent decree.
Okay. Well, the consent decrees essentially started with licensees filing their renewal applications on the radio side. And there is a question in the renewal application as to whether the licensee can certify compliance with the public file requirements. And the political files are a subset of the public file. And so if a licensee is unable to certify compliance with their public file obligations, then they mark no, and then they have to provide an exhibit. And in the exhibit, they explain why they were unable to certify compliance with public file obligations. And if they indicate in their exhibit that the reason they couldn't certify was because of political file problems, in other words, they uploaded late for files, then the folks in audio services who are processing the renewal applications will forward the materials to Bobby, Sima, and me, and we will prepare consent decrees. And during the time that the consent decrees are being prepared, the license renewal applications are being placed on hold, pending resolution of the whole matter. So the consent decrees are, of course, legal documents, and you don't necessarily need a lawyer, but it's always a good thing to have a lawyer to review this legal document. It's an agreement to resolve an investigation into the station's conduct, the licensee's conduct. So there are essentially two parts to any consent decree. The Media Bureau is signing on to the consent decree and agreeing to do several things. And the licensee is, in turn, signing on to the consent decree and agreeing to do several things. So let me just talk on the bottom of the screen there. You see what the Media Bureau is agreeing to in these consent decrees. And if the consent decree is signed by both parties, the Media Bureau will agree to process the license renewal applications in the ordinary course. And you know, we never say that we're going to grant the applications, because there may be a reason that the folks in the audio division are holding up the application in addition to the political file problems. But if the political file problem is resolved, then the application is returned to active status, and if it is otherwise grantable, then the Media Bureau will grant the application. So that certainly is a plus to signing on to the consent decree. The consent decrees that we are sending out now also state that the Media Bureau will not suspend processing of future applications that the licensee files, future license renewal applications, even if those future license renewal applications are unable to certify compliance. So this is, frankly, rather huge for licensees, that all their future license renewal applications in this current cycle, which I believe goes through 2022, if those applications have certification problems of the kind I described, they will not be held up. And then another huge element to the consent decree is that none of them involve any monetary sanctions. So those three elements that the Bureau is agreeing to are big for licensees. They are a big benefit. The other side of the coin is that the licensees have obligations. And the obligation, all these obligations are intended to ensure that licensees and their individual stations have the political files on their radar screens. We found, as Bobby described early on, that there was widespread non-compliance in the industry. So this whole exercise is intended to ensure that licensees come into compliance and understand what their obligations are. So among the obligations that licensees have under these consent decrees, they have to name someone within the company to be a compliance officer. That's a point person who will oversee and ensure that there's compliance, that things are uploaded on time, that the contents of the political files are complete. They have to create, licensee have to create a manual. A manual can be as broad and as expansive as a 3-ring binder with subdividers, or it could be a one-pager that describes what employees should be doing with regard to political advertising. And the NAB may be in a position to assist stations in creating a compliance manual. So that's certainly helpful. And maybe other licensees perhaps may be able to help, or state associations may be able to help in creating a manual for smaller stations that are unable to. Of course, lawyers are always willing to help create manuals for stations. Another obligation that stations have is to train their employees. Not necessarily all employees at the station, that's certainly not what we mean, but to train employees who have the task of uploading materials to their political files. Those employees should know what they're doing. So stations have an obligation to train those employees who are involved in these activities to do it properly. And then the consent decrees also require two compliance reports to be filed. The first one will be filed in December of this year and will cover a 30-day period leading up to this November's election. And then the second compliance report will be in a year, and they'll file it in December of 2021 and cover the 6 months leading up to the November election next year. And then stations pursuant to the consent decree, and this is common to all consent decrees, including those that the Enforcement Bureau generates, that stations have to report non-compliance to the FCC. And again, all these obligations are I don't want to say simply intended, but are intended to ensure that licensees know what their obligations are, have political files on their radar screens, and are able to comply with the political file rules, because political files are critically important to the public and other individuals.
Thank you, Gary. This finishes our summary. We recognize that on these political file issues and other political issues are complicated. And one thing about the FCC's political programming branch, perhaps more than any other government institution that I know of, is they are willing to help. And they are willing to be responsive to phone calls and to email questions. And on this slide, you have all three of their email addresses and their phone numbers. If you have FCC counsel, particularly on issues where it's a very close question, you may want to consult them. You may be able to get help from your state broadcaster association, and that may be particularly useful if you have a question about things like whether a party can be a candidate's authorized committee, because that is often a matter of state law. And if you're an NAB member, NAB provides political information to its members. So all these resources are available to stations if they have questions as they go through the rest of this election cycle. And with that, we will turn to questions. And David, I think that's now up to you.
I do. Thank you. Thank you, Jack, and thank you to all the panelists. I must confess, I've been doing these for a long time, and I have never had an explosion of questions like I've had for this webinar. We will do our best to answer them all, but why don't we just begin? Some very basics. First of all, and I'll ask these to Bobby, to Gary, and Sima. These rules apply, do these rules apply to all broadcasters, radio and television, regardless of size?
Yes.
The answer to that is yes.
Okay. So there are no exemptions even for the smallest of stations?
That's correct.
Okay. I have an entire set of questions that have come in regarding non-commercial stations. In particular, first of all, can a non-commercial station take a political ad? And what must they do if an ad is taken? Can you rely on, or do you have to use the wording of the candidate that said sponsored by, the candidate ad, or do I rely on the FCC rules regarding non-commercial acknowledgement? And in a separate vein, what happens if you are on a public station on a show that's not a regularly scheduled newscast? Will a public station have to upload that into the political file? So if you could just address non-commercial stations in general, that would be helpful. Bob, Sima, Gary?
Well, Bobby, help me out here, but non-commercial stations aren't allowed to have commercials, but they can have enhanced underwriting, of course. We rarely hear about non-commercial educational stations receiving requests for the purchase of time. They have to come in the form, I guess, of donations to the station. Most non-commercial stations are reluctant because they don't want to have to take a position, and airing the reference to a political candidate may suggest that they are endorsing that candidate. Bobby, do you is that something that
Well,
you have familiarity with?
there was a moment in time when there were federal markets that were seeking placement on non-commercial stations all over the country. And ultimately, because of that, Congress amended the reasonable access provision, which is the provision that actually mandates that federal candidates be sold reasonable amounts of time if they have the money to buy it, and the stations cannot refuse to sell them time. And it used to apply to the non-commercial stations, but the amendment removed non-commercial stations from that particular part of the equation. Our Communications Act also, I mean, it does prohibit, I think, the sale of time to political advertisers, or any advertisers for that matter, if they're in the non-commercial identified educational status. So it rarely comes up. And so I can't recall the last time anybody asked us about a non-commercial station, but I saw, at least as these things were being prompted up on the screen, I could see that there were at least 2 or 3 questions that involved it.
All right. Well,
I think the short answer is that you're not required to do anything in that realm for federal candidates, state or local, and you certainly aren't required on the non-commercial side to accept issue advertising.
I will say that if a non-commercial station allows a candidate to use the station and it's not in an exempt type of program, a news-related type of program, information about that use does have to be uploaded to the station's political file.
Yeah. In those questions, and obviously they should probably talk to their counsel as well. Let's move on. We received a lot of questions about the timing of when these have to be placed in the political file. Let me give you some examples. I take an order in August for an political ad that's going to appear in October. Now, when I get the order, I don't get all the information necessary to complete the NAB form until, let's say, mid-September. When do I have to put this in the file? I assume at the time or pretty close to when the order is made, not when it appears on the air. If you guys could just, I know you discussed it a little bit, if you could just focus in on that a little bit, that'd be great. Gary?
Well, since I did the timeliness issue.
Okay, go ahead.
I'll answer that question. If they get a complete order as described by Gary, then at that moment in time, that's within a day of that order being made, even, it can be a couple of months before the order is actually going to start running. That's the moment in time that order needs to go into the file. Despite the fact that it may seem a little bit counterintuitive for people thinking, well, isn't it more important to be closer to the time that it's actually going to be launched on the air? But the fact is that it does give stations a bright line. If they receive an order and they accept it, that's the moment that they're supposed to put the disclosure into the file.
Okay. Also, then following up. In this concerns compliance issues. We received a number of questions about, okay, folks may not have done that and not have put it on the file at the right time. What should they do now in order to either update or correct, or what's the best practice for them to go forward now?
My suggestion, I think the best practice would be to take information about that buy and put it in the file as soon as you can. If there's a reason why there was some delay, why you were not able to put it in on time, associate with that upload a notation. Upload a piece of paper with an explanation of why it wasn't uploaded in a timely manner. In other words, if there are unusual circumstances that would have delayed the upload, note that in the upload so that people are aware who look at the file, understand what the circumstances were. I guess you could characterize it as full disclosure.
Do stations in the process where you have, quote, free candidate time, or candidates appearing for free or during news, or even if it's during news shows, what have you, does that information have to be uploaded, or is this clearly paid candidate time at this point?
No, the only thing that's required for candidate appearances are what the statute calls are uses, and there are appearances by candidates outside of the exempt programs. So that if they're within those categories of bona fide news programming, which is bona fide newscasts, interview programs, on-the-spot coverage of news events like debates and stuff along that line, and appearances by candidates in documentaries where their appearances incidental to the subject matter. You know, a biographical documentary about a particular candidate would certainly not be an exempt documentary appearance. So, I mean, those appearances are not required. Only thing that goes in the file relating to candidates is obviously all the spot advertising that's bought, the program length time that they may be buying for long segments of political advertising, and appearances on, on programs that are not within the four news exemptions.
You know, I will add with regard, David, to free time, that most of the questions we get about free time and candidates involve station and on-air employees who happen to get this crazy idea to run for elective office.
Yes.
And we always get questions as to whether, does the FCC require those employees to go off the air? Are we going to make a weatherman or a sportscaster go off the air if that person is running for office? And the answer is the FCC does not require the person to go off the air. The FCC requires the station to upload information about that particular use. So whether the individual remains on the air or not is a business decision by the station. The station essentially has three choices when it has an employee who is running for elective office. The station can leave the individual on the air and let him or her carry out their usual activities, but that would mean entertaining requests for equal opportunities from opposing candidates for that same office. That's option number one. Option number two is to ask the on-air employee to take a leave of absence or a vacation for a few weeks until the election is over. That's certainly option number two. Option number three sometimes works in small communities where the station and all the opposing candidates and the on-air candidate get together and they try to reach an agreement, and it would go something like, if the on-air employee agrees to do his or her job and not advocate their candidacy on the air, then the other opposing candidates agree not to assert their equal opportunity rights. Sometimes that works, sometimes it doesn't, but it is an option that is available. But the bottom line is, if an on-air employee who is running for office is on the air, that would constitute a use, and information about that use would have to be uploaded to the political files.
Let me clarify.
Can I add two things on that? One is, it is important for stations, particularly stations with a significant number of on-air employees, to make clear there's a policy that if an employee is thinking of running for office, they need to tell management before they file, so you can make these decisions and plan. The other thing is to watch out for is advertisers, people who appear on advertisements, and the spokesman, say the spokesman for your local Ford dealer decides to run for school board. That person isn't likely to tell you that they're doing that, but you need to watch out because those are non-exempt uses.
And it's always auto dealerships. I don't know why, but auto dealers always want to be in their own commercials.
Right.
Well, maybe auto dealers and politicians have something in common. No offense to any auto dealers out
I
there.
think you mean used car dealers, right?
All right, I think
Yeah,
we're going to
that's probably
move
what
on
I'm-
from that because auto dealers are the most important advertising sector of the broadcast industry, and we
Yeah,
love
they are.
automobile dealers. Let me ask you, and Sima, let me address this to you. I've got a number of questions that have said, okay, since we're in the middle of COVID, is the FCC still active? I mean, how can I continue to upload materials? How can, sort of we work through this if we have issues or problems? Address that if you will, because I think you guys are still operating, right?
We are active, yes. And our contractors are still active, including the folks that manage this database. Now, I can't say that there haven't been any bumps. There probably have been, although I think at this point, we are operational as we were before COVID. So in terms of your obligations to upload, as long as the database is running, your obligations will continue. We know that there are sometimes outages, that sometimes there's some delay between an upload and the visibility of the document itself. Luckily, in that case, the timestamp saves you because the timestamp will reflect the time that the upload actually occurred. So even if you don't see that particular file in the folder where you put it after you've done it and you're thinking, where is it? There might be some lag time between the posting time and the actual upload time, but it should be there. So I would recommend just checking back in a few hours. Now, if it's not there after you've given it a day, then I would contact the database manager information. You can also email one of us if you're having trouble getting through. We can relay your questions. There are people within the Bureau that also have more direct, regular contact with the database folks. So don't feel like if you don't get an answer right away that you're just stuck.
And I would add too that if there's a significant delay in uploading it because the FCC's system has prevented you from doing what you need to do, and that delay adversely indicates that you may have uploaded in an untimely manner, when you are able to upload, put information in that file about what the unusual circumstance was that prevented you from doing it in a timely manner. Again, that falls under the full disclosure best practice plan.
And I saw, sorry, David, just to add one thing. No, I saw in the chat that some people had asked whether we had particular naming conventions or a preference on how you name your files. We don't have any requirements with respect to that. My recommendation, I think, is that you name your files in a way that makes it very clear what they are. And if you supplement those files, use the same name and just add, supplement as of such and such date. So that when it's in the folder, you'll see that everything relates to one particular order. And all of those supplementary files are an addendum to that particular order. And I think that would help you and help us, should we be in a situation where we have to review everything.
What happens, one question that we have is what happens when you take an order and you're ready to broadcast it, but then, at least in the process, you have been unable to obtain the necessary information from the political campaign committee, or if it's a third-party purchase on an issue ad, obtaining all that information. Should we just put that in the file saying we tried? What are the obligations to obtain that information before you air it? And indeed, more importantly, before you file it?
Well, I think this is kind of along the same lines as what we've been saying, add the information as you get it. We expect you to make a reasonable, diligent effort. Unfortunately, we only see what the stations can do, and our enforcement only falls on the stations. So it's the station's obligation to meet those requirements.
Yeah, but I would answer I would say that just in the same vein that I think both Sima and Gary have been illustrating, if they note in the file these kinds of situations where they've received something and they've got the advertiser or the agency for the advertiser has not been forthcoming, or they haven't provided you with the information that you need, and particularly if you're dealing with candidate advertising, and certainly if you're dealing with federal candidates, because they have that statutory right, or you've got people that are seeking equal opportunities based on other candidates' purchases, then it gets tricky. I don't think that you can deny them the access because you haven't gotten that kind of information. But I think if you note in the file that you tried and this is what you got, and you're still waiting for information from that, if I were reviewing a situation like that, I would certainly be all in for forgiving the lapse of time. And I think the same would be said for Sima and Gary.
What about
common sense.
What about political rebates? In which, for some reason, an ad got preempted or what have you, you're making make goods. How do you record that and how do you file that?
I get that's part of the reconciliation of an agreement. If you have an order that's in the file, and just as an example, more typical than the rebate, if you have preemptible time, and some of it gets preempted, and stations are obviously always choose to do make good so that they can retain the money. It would only be in cases where they don't provide make goods and they do have to do rebates. All of those kinds of things that happen in relationship, again, to a particular transaction are supposed to go in the file, as the deal unfolds. And again, as Sima said, they should be associated with each other so that people looking at the file won't think that they're seeing different transactions on a particular day.
And it sounds kind of abstract, but in reality, in the file, because you can create as many subfolders as needed within these system folders, create a particular folder for that particular agreement, and everything can go in there, making it easier for you to keep track of where everything is. Okay.
We've got a number of questions. I realize this may be a delicate question, but we've got a number of questions involving, let's say, regional radio networks, where the network itself sells the political time and sells the political ad. That is the data from that, even though it's not sold directly by the station. I assume that they must get the information from the network and then put it in their file. Is that sort of the best practice at this point?
Yeah.
That would be, yeah.
Yes, we've taken the position that stations are responsible for the content of their broadcasts. And it doesn't matter whether the political ad that they broadcast originates down the hall in a studio or originates 2,000 miles away in New York at the headquarters of a network. Our position is that stations should endeavor to put information about the ads that they broadcast into their political files in a timely manner. Now that certainly means communicating with the network and ensuring that the stations get the information from the networks that they need to put in their political files so that the stations comply with their obligations. It's the station that's on the hook, essentially, when it comes to maintaining timely and accurate political files.
Let's turn that around just a little bit. I have a lot of stations that may broker time to third parties or lease time, and that the lessee or the entity that's doing the brokering may in turn sell a local ad. Usually these are very local arrangements. I assume the station in that context would have to include any of those arrangements in its political file as well.
Again, we would tell the stations that when they're brokering time, that they should be stipulating in the brokerage agreement that, in fact, they would like to get to have knowledge of the fact that they're about to sell political advertising, because there are different things that the station needs to be concerned with, like the charges to these candidates and so forth, and certainly for equal time purposes. And I think that they should be sort of monitoring in that vein, but by stipulating that anything that's in the realm of political advertising is something that you need to run by the station first, so that they're not caught off guard or completely unaware. The problem with these situations where people are not being informed about advertising that's been sold on their stations, but not by them, is these situations where they may get a competing candidate to a candidate that's bought time from the broker will come and say, well, I have an equal time right on your station. And the station goes, we don't know what you're talking about. We didn't sell any time to so-and-so. And they'll say, well, it ran on your station. So to prevent them from being blindsided in that way, they should be stipulating in these contracts with brokers that they need to be informed about political advertising activity. Doesn't mean they will stop them, but they should be informed beforehand.
And actually, I've represented a number of clients who the way I've recommended they handle so if you broker 3 hours in the afternoon to somebody, is specify that any political buy in that time must go through the station and not through the time broker, even though the revenue may go to the time broker. And that ensures that the station has access to the information and can upload it to its political file.
Right.
I hate to go back over this again, but we have so many questions on this. And that is, when should you actually place the order in the file? You've got a lot of negotiation going back. You've got folks who are saying, once I get all the information, if you could just repeat one more time, and I know we've gone over it, exactly when these documents need to be filed.
Within 24 hours of the time that you have a full-fledged order in front of you and one that is required to be put into the file. There's a 24-hour grace period that we've interpreted. As Gary also mentioned, though, there can be situations, and the rules account for them, where they're absent unusual circumstances. So in a situation where a small station that has only 3 or 4 employees, or even less, 2 employees, and one of them has gotten COVID, and so that the person that's normally the person that's been designated to do political stuff is out sick and unavailable. Those are the kinds of situations, again, that should be noted in the file as an unusual circumstance. And frankly, at least from my experience, if you're looking in a file and you find these notations of things like that, it explains it, and then I think we would move on. It's only when there's nothing that explains what the delay has been, but absent a circumstance that should delay it, they have 24 hours to put it in. And as I said, only time that is different in time is on Friday. Friday deals with political advertisers and issue folks that need to be put in the file. They would have until Monday to do it, because Monday would be the next business day.
Okay, and Bobby, a full-fledged order means someone who is not just fishing around for rates, but actually has a full order, an order ready to purchase time.
Right. Yeah. Exactly.
Okay.
It has to be, an offer that if it's accepted by the station becomes the deal that's represented. And both the request for that time, if it's a complete order and it has all the bells and whistles of a schedule and the classes they want and so on and so forth. There are 2 moments in time that are identified in the rules and in the statute. One is the request, as Gary explained, and the other is the disposition of that request. Oftentimes, they can happen at the same moment in time. Someone can present an order for time that needs to be presented into the file once it becomes accepted, and the station may say instantaneously, deal. And it may be through a telephone conversation with an advertiser, particularly in smaller markets where there's a much more, interpersonal kind of knowledge between people that know each other in a small community.
Okay.
So it can vary from circumstance to circumstance, but typically it has to be something that can be acted upon. The stations can't act on something that's not specific. And as Gary got into, the request for just fishing kinds of requests, wanting to know about avails, wanting to know how much it'll cost to do this, and if I put these kinds of spots together, will I get a discount? All those kinds of questions do not form a complete order. A complete order is basically is an order that's been presented that is a schedule of time that has all of the elements of what an order needs to have for the station to know what it's considering to accept or modify or reject.
Okay. And if the order is presented but ultimately canceled, let's say, the order is subsequently canceled, do I have to put the cancellation in the file and upload it there? Is that sort of the final disposition, or how would that work?
Well, I always think I've heard everything under the sun. I've never heard that.
I just
but
got
if
it, Bobby. It just
in the
popped
file,
in.
if they put something in the file about a particular transaction that gets canceled, then it seems natural to presume that it would be nice to put in the file of the fact that it never happened, that it was canceled by the advertiser.
Well, ultimately, you do have to put in a schedule of when spots ran, and that's ultimately has to go in the file. And obviously, if the spots never aired, you would say these spots never aired and the order was canceled. And you could upload that as a supplemental document to the folder where you uploaded the order to begin with.
Well, the same goes for if you receive a firm request to buy time and the station decides to reject it because perhaps it's a local candidate and the station has made the decision not to run ads for that particular office. So they upload the request and they note that it was rejected. That's one of the requirements for a candidate ads, that you note whether it was accepted or rejected.
Some basic questions about if and we're at where it's a 219, and frankly, we won't get to all these questions, but I don't want to exhaust you, not yet anyway. If I own a cluster, let's say a cluster of radio stations, and I am having political time that is bought, and people buy as a cluster, for example, they buy all 4 radio stations, do I have to have a separate political file for each station? Number one. And number 2, if I'm buying time across all those stations, I assume I would have to file that order in each station's political file. I was wondering if you could address that.
That's correct. Each and every participant in a cluster, whether it's 4, 3, 6, 7, 8, which are in some cases by the larger group owners, all of those stations that participate in that cluster have separate stuff in their file.
Okay. And would I have to then, if I have 5 stations and I show an ad on each station, would I have to divide up the value of the spot that's just on that station, or could I take the uniform agreement and just file it in all 5?
Well, now you're going to get into a whole different area, but I'll just explain it very quickly.
Okay.
The clusters have become a very beneficial situation rate-wise for the political advertising world. Because we have for many, many years, we probably never understood that it was going to go down this road, but the clusters are essentially groups of stations, oftentimes commonly owned, sometimes they're put together, manually, so to speak. And the charges that the stations receive from those clusters, let's just say I have a commercial advertiser that's bought all 5 stations, because they're a commercial advertiser, and regardless of format, they sell something that all 5 stations can help them sell. The stations do not need to consider what they get from that cluster network type transaction in their lowest unit charge. So if a political advertiser, a candidate advertiser doesn't want all 5 stations, it only wants 1 or 2 of them because they're the kinds of stations that are more conducive to reaching electorate and voters, then the stations have the ability to charge them more than they've gotten from the cluster. Frankly, it's something that has become very relevant for us lately when we've had a couple of lowest unit charge complaints where either a disgruntled employee or someone reveals to us some inside information about a commercial advertiser that's getting much better rates at the station than they're providing in their lowest unit charge to candidates. We have discovered that in almost every instance that's occurred, they're involved in clusters. And so that somebody inside the station not understanding all this gobbledygook would think that they had been, the station was acting improperly, when in fact they were not. And at least the last 3 or 4 instances that we've seen of that, it's turned out that the stations did nothing wrong because these participants in these clusters or anything that's 2 or more stations in any combination is considered to be a situation where the individual stations need not consider what they get from the arrangement. So going way, way back, with AM FM combos, which used to be pretty typical, and there would be a combo rate. We determined that in that era, and I'm sure it still exists, that if you wanted the combo rate, you would need to buy both stations. If you wanted to buy only the AM station or the FM station, those stations could have a larger than a proportionate of the combo rate. I may be getting too confusing about this,
Okay.
but the simple point is if there's 2 or more stations involved in a sale of time, the individual stations need not consider what they've gotten from that when they sit down to figure out what their lowest unit charges are for candidates.
But again, we're talking about rates now, but in terms of the political files, if you have an ad which is being broadcast by a group of stations, each station has to put information about that ad into its political file. For example, if it's a candidate ad, the opposing candidates can approach only one of the stations. They need to know what that station broadcast.
Right, but they don't need to
But
put,
not the rate.
to answer the question specifically, you would not have to break down the rate in the public file. You may have to do some, depending on how the structure is, you may have to do it somewhat in terms of showing you charge lowest unit charge or equal opportunities, but that does not have to go in the public file.
Okay.
That's correct. The rates do not.
Okay, just following up then without getting into too much detail on this, for a television station that has both a main channel and sub-channel, since that is one station, I assume the station only has to have one political fund.
I think that's correct. You have any different answer for that, Gary? I don't think so.
I finally got one right.
I think
Singular. It's a singular license. I don't know how, I don't think we've ever suggested to people that they have to create a separate political file for each and every one of their potential 5 additional sub-channels. So, no, I think it's the same licensee at all. I don't know how they'll break it down in the file, but that would be my answer.
Okay. We have now run our course. Any final thoughts from Jack? If you want to just, guys, I will have something at the end, but if you folks have any final thoughts based on what you've talked about today.
I think there were a lot of interesting questions that we didn't have time to get to. Some of them go beyond the scope of this. It may be that if you have continuing confusion, again, we're going to make the slides available, David, on the state association websites. That's where they're going to be.
Yeah, yes.
And that
I'd also suggest. No, I'm sorry.
There will be a list of we have the list of people you can contact. So you have specific implementation questions, your own council, state association, the 3 people from the FCC, the NAB are all good sources on that.
Bobby, Gary, Sima? Final thoughts?
Well, the only thing
It's
I
been
would
a
say,
pleasure. It's been a pleasure. You know, we welcome this opportunity to speak with you and answer your questions, and we are here. You know, contact us if you have any particular questions.
Bobby?
I was just going to reiterate what I said in the beginning, because my philosophy for dealing with this whole area has always been to facilitate the ability of people, particularly the smaller broadcasters and communities that are not, that don't have the same kind of intensity of political advertising and the kind of situation that we're finding now with these consent decrees. I will bend over backwards to assist people in any way we can. We're free. You can communicate with us in whatever capacity you choose. You can email us, as I said before, and give us a telephone number to call, or we can respond to you via email. Whatever you choose, you should feel free to do that. And I will say that in 99% of the cases, we typically respond to people the same day as the incoming, no matter whether it's been by email or a phone call.
Sima?
Well, I think I nominated myself to be the mechanics expert on this, but it's really, don't be scared of the process. Again, you know, it sounds more complicated than it really is, and we don't have a lot of very specific rules about, you know, using the online files themselves. As long as you're putting your information in there and it's generally in the right place, the rest is up to your discretion as to, you know, how you name your files, or you know, how you decide to supplement your information. But if you're following, you know, the actual rules that we have set forth, the rest of it is not that scary.
Well, I want to thank all of you, and just for some housekeeping things, this will be archived. Also, we will be sending, and I will be sending that link to the state associations, and they will distribute it out, as well as the slide deck. At its height, we had roughly about 940 people on, which I think is a terrific number and shows that this is a very, very important issue. If you are a station that receives a consent decree, these are important. There are actions for you to take. Please do so. In addition, if you have made errors, you really need to look at, when it comes to renewal time, whether there is a box that said you've been in compliance with all the FCC rules. And if you have made errors, you really need to talk to your lawyer, because if you check off the box that you've been in full compliance, you may not have been, and there may be some significant ramifications for that. Also, finally, a lot of you have various state public file inspections. It's important to know that even if you have been inspected, and various states do it differently, even if you have been inspected, the political file obligation is an ongoing requirement. So if I was inspected last week, but I'm selling candidate ads this week, the fact that you passed inspection through an ABET program or a mock inspection program a week earlier doesn't relieve you of the obligation to continually update your political file. So I think that's important for stations going forward. And I think with that, unless folks have something else to add, I want to thank all of you for participating, and look forward. We have a zillion more questions, and we'll do our best to answer them going forward.
Thank you.
Thank you all very, very much.
Thanks, David.